So my name is Griffin. I am the research director of the Access to Justice Lab at Harvard Law School. And the A to J Lab, which is a little over a year old now, is really trying to make the legal profession an empirical one. The word empirical, the idea of empiricism, takes a lot of forms. And in fact, before I joined the lab, I was one of many growing numbers of empirical legal studies scholars in the legal academic community. And now that I've been involved with the lab's work for as long as I have, I realize that that sort of empiricism is almost like legal history. Because even if you're studying something that happened 1, 2, 3 years ago, even though it's fairly recent, all that you're getting a handle on is something that has already occurred. Some idea that has maybe had its time, maybe still will have some ways to go, but it is something that has already taken place. And the lab is all about innovation. And the lab is all about the principles and the ideas that have been discussed at today's summit. Namely, taking lessons from other areas of inquiry, not just looking for the solutions to legal problems in the legal profession, among lawyers, among judges, among court administrators. Realizing that graphic design, psychology, adult education, all have a role to play in narrowing the justice gap. And what we do is less and less take those ideas and create our own intervention, our own innovation to evaluate, and more partner with all of you, with courts, with lawyers, administrators, sometimes working with court users themselves to figure out what their experiences are like, and then putting those ideas to the most rigorous form of evaluation possible, the randomized controlled trial. And when I go around to various conferences and meetings like this, I know that I'm getting pretty evangelical. I'm proselytizing on the benefits of the RCT, something that is less and less anathema to the legal community, but still something that's not well appreciated. And in the short time that I have right now, and of course I'm happy to discuss this later on and after we all leave here, is that when you're thinking about the ideas that you may take with you from here today, from this summit, or the ideas that you dream up after you've left and you've taken the principles with you, some of them are the type that you just want to prototype and get out into the world. Others are requiring enough time investment, enough resource investment, that you really want to understand whether they work, whether they have a causal effect on the outcomes that you care about. And for those types of projects, that's where we really encourage the use of the randomized controlled trial, our evaluation methodology. The reason is because even though it's the gold standard of causal inference, it's costly itself. Now, we're thankful to the Laura and John Arnold Foundation for funding the lab and its work and covering that part of it. But there is time that's involved. If you want a quick and dirty answer to whether something works, RCTs are not the way to go. For the vast majority of our evaluations, it will take, on average, 2 years for really small population sizes, maybe closer to 3, until you just generate enough data to analyze. And then it takes us some time to crunch those numbers. So when I was speaking of empiricism in the law as legal history, I encourage you all to think of our evaluations and our methodology as shaping truly the future of the law, because what you do in creating these innovations and putting it to the test is generate new data. The data come through as the innovation is interacting with the world. We gather that, and then we can say something far more reliable than we ever could with backward-looking statistical techniques. We work in all sorts of areas, both civil and criminal, all the major areas that you would think of in civil legal aid, landlord-tenant issues, family law, consumer debt, intimate partner violence. And with the criminal law realm, we're working on a lot of bail reform efforts and pretrial release decision-making. So we cover the gamut, but we're interested in new areas to explore. Maybe there are innovations in the tax space. There was discussion at the beginning during the keynote about how difficult it is. We all know, even if we're, maybe not if we're tax lawyers, but even if we're learned in the law and we took a Fed tax course, it's still a drag to fill out these returns. And maybe there are ways that we can think to innovate, make that better, and then put it to the test. So again, I look forward to speaking with you later on about how we can get involved, and just in general about how the RCT and solid, rigorous evaluation designs can help you in your work.